tonight, which is Daniel Hernandez. So we were formerly known as Protection and Advocacy. We are a nonprofit organization founded in 1978. We are federally mandated to provide legal services for people with disabilities. Issues that we can work on can be anything from special education, regional center services, public benefits, housing, employment, services as it relates to the Department of Rehab, and so forth. Our offices are located in Sacramento, Los Angeles, Bay Area, and San Diego. We have smaller offices in the Fresno, Ontario, and Modesto area. So today, your presenter, Daniel Hernandez, is our legal clinic attorney with the Advocacy and Community Engagement Group, known as ACE, at Disability Rights California. He was born in Santa Ana, California, to a Mexican immigrant parents. He began practicing law in 2021. He has experience in immigration, housing, and some public benefit matters. I'll now turn it over to Daniel. Thank you, everyone.
Great, thank you, Lonnie. And good evening, everyone. Thank you for having us today. And I'm going to wait just a few moments until the PowerPoint presentation is shared on the screen. Great, thank you, Lonnie. So again, my name is Daniel Hernandez. I use he, him pronouns. And today's topic is going to be Section 504 of the Rehabilitation Act of 1973, which we'll call Section 504 for short, and the Americans with Disabilities Act, which we will call the ADA for short. Okay, we can go to the next slide, please. So before we begin, we want to provide a short disclaimer that the following presentation is meant for education only and doesn't constitute legal advice nor counsel. And that's because your situation may be unique and require careful attention. We also want you to keep in mind that the information in these slides could become out of date in the future. And that's because the laws and local practices relating to these matters are constantly developing. And that's to say, right, that we want you to be aware that if you look at this material in 1 or 2 or 3 years from now, there's a possibility that some of the information may have changed at that time. So we just want you to be aware of that. Okay, we can go to the next slide. Now let's give you a brief overview of what we're going to be discussing today. We will be going over the difference between federal and state laws, which is a very important concept. We'll also give you context of Section 504 and the ADA. We'll give you an overview of Section 504. We'll then give you an overview of the ADA. Then we'll provide you some information and tips on how you can enforce your rights under those laws. And at the end, we'll provide a list of various resources. Great. Okay. So here on the screen, we have an outline of the map of the United States. And you'll see there that the state of California is shaded in yellow. And this is to show that federal laws apply to every single state in the country or in the United States, including California. However, state laws are different because they apply to individual states. So for example, California laws will only apply to California, or what you see in yellow, shaded in yellow. Even so, federal laws and state laws can coexist, right? They can exist together, but certain rules have to be followed, which we will explain in the next slide. Okay, so let's continue talking about federal versus state laws. So federal laws establish minimum standards and protections that apply across all the states in the country. Applies to California, Nevada, Idaho, New York, every single state in the country. This means that federal laws are, let's say, the floor. And we'll later discuss, for example, the Americans with Disabilities Act, which is one of the floors of legal protections for people with disabilities. But federal laws are the floor or the minimum amount of protection that can be provided to people. State laws, they complement federal laws by providing additional protections or requirements specific to that state. And state laws cannot contradict or undermine federal laws. And all of this might not make sense right now, but we'll go to the next slide and we'll provide an example of what this looks like. So here you see a map, right? And we have the state of California shaded in yellow and the rest of the country shaded in white. And you'll see some money or dollar amounts, right? For California, you'll see $16.50 per hour. And for the rest of it, you see $7.25 per hour. So there's a federal law stating that the minimum wage is $7.25 an hour for most employees. This means that states cannot have a law where the minimum wage is less than $7.25 an hour for certain employees. And that's important. But, right, a state law can provide a minimum wage that is higher. Because again, federal law is the floor. It's the minimum protection that you can provide. But states can provide more in their laws, more protection. Like in California, where some of you may know, in 2025, the minimum wage is $16.50 for certain employees. And some of you may know as well that for employees of fast food restaurants, the hourly amount is $20. The minimum wage is $20 per hour. So in this case, the federal law gives us the basic rule that applies to all the states. It's the minimum protection that states can provide. But states can certainly provide more if they want. Here, California provides more than the minimum wage of $7.25, and that's okay. That's allowed. State laws can do this because more protections is good, but having less protection is not allowed. We can go to the next slide. So throughout the presentation, we're going to have some multiple choice questions. So if you're brave, feel free to, I'll read the question out loud and read the answer choices. And if you're feeling brave, you can just type in the chat the answer that you think is correct. And then afterward, we'll discuss what the correct answer is and why. So this is going to test your knowledge of federal versus state laws or California law. So the question is, a federal law is created that requires public buses to have 4 priority seats for people who are 60 years of age or older, pregnant, or disabled. There is a California law, however, that requires 4 priority seats for people who are 55 years of age or older, pregnant, or disabled. So the question is, does California have to change its law because it's different from federal law? And you have 2 choices here. A, yes, the California law contradicts or undermines federal law. Or B, no, the California law provides more protections to people, so this is allowed. So we're going to give people a few moments. Great, thank you everyone for participating. Great, we'll give it a few more seconds. Fantastic. We can go to the next slide to reveal the answer. The correct answer is B, no. So here the federal law is a floor of protection, right? It's the minimum amount of protection. So this means that a state like California can provide less protection or less rights, but it can provide more for its people. Here, California law is different because it includes anyone 55 years of age or older. This protects or helps more people in California, and this is okay. And so for that reason, it doesn't undermine nor contradict the federal law. So good job, everybody got it correct. Okay, we can go to the next slide. So today we will be discussing Section 504 and the ADA, and both of these are federal laws. So they're the floor of protection, right? They provide the minimum amount of protection all across the country. However, there are many other laws that protect people with disabilities against discrimination. And here we have a list of those, right? Some California laws and some federal laws that provide protections or rights to people with disabilities against discrimination. So some of you may already know what discrimination is, but I'm going to provide an explanation or definition of discrimination. So discrimination refers to treating someone unfairly or differently based on certain characteristics. So the characteristics can include things such as race, nationality, religion, sex, which includes pregnancy, gender identity, and sexual orientation. We also have characteristics like age and disability, which is a characteristic that we are discussing today, disability. So I'm not going to go into detail in terms of all these laws that are listed, but in the next few slides, we will be discussing Section 504 and the ADA. Okay, can go to the next slide. So here on the screen, you see a timeline of some important federal laws that provide legal protection to people with disabilities. In other words, Section 504 and the ADA. So I'm going to give you a brief history, right, of these laws. So Section 504 was enacted in 1973, right? And this was after many activists, and a lot of them from California, took part in what was called the independent living movement, where people with disabilities fought really hard to advocate for not only their own rights, but the rights of their peers. So Section 504 was enacted to provide federal protections to people with disabilities. And later on, we'll explain why Section 504 is different from the ADA, but it was the first law that was passed. The next, we have the Americans with Disabilities Act, which was enacted in 1990, a few years after Section 504, and we call it the ADA. And sometimes a lot of times people don't realize, but the ADA was actually amended in 2008. So we have what's known as the ADA Amendments Act. And it just provides slightly more protections to people with disabilities. And then it also provides a lot of explanation as to people's rights. So in the next few slides, we'll go into more detail about these two federal laws. You can go to the next slide, please. So I know, of course, that we are people with disabilities, right? And we have family members, loved ones with disabilities. So oftentimes people ask the question, so what exactly is a person with a disability? And that's important, right? Because these federal laws protect only people with disabilities. So under federal law, either Section 504 or the ADA, a person with a disability is a person that has a physical or mental impairment that substantially limits one or more major life activities. And then the next slide will tell you what a major life activity is, but just keep that in mind. Or is a person with a disability is a person with a history of a physical or mental impairment. Or a person with a disability is a person that is regarded as having such physical or mental impairment. Okay. And then at the very bottom, you see very small text. And we want to share, right, that there's an exception in California to this definition for people with disabilities. So in California, the definition is more broad. It's more general because in California, the physical or mental impairment only has to limit a major life activity. It doesn't have to substantially limit a major life activity. So what does that mean? So that means that California uh, provides more protections to people with disabilities in the state, right? Because it means that more conditions can be considered a disability. Of course, it depends on the specific situation, but one example could be uh, obesity or complications of obesity. In California, that can be seen as a disability if it substantially limits, no, if it limits a major life activity in California, but not necessarily under federal law, right? Because under federal law, it has to substantially limit a major life activity. And another thing that I want to share with all of you, now that we learned the difference between federal and state laws, um, earlier we stated that federal laws are the floor of protection or minimum protection. And this is a good example of that because the federal law or the federal definition of a person with a disability is the floor. But as we see here, California law makes that definition more broad. So it provides additional protection to people of California with disabilities. Okay, so if we can go to the next slide. I mentioned major life activities, right? So a person with a disability is a person with a mental or physical impairment um, where major life activities are substantially limited or limited. So here we have a list of the different types of major life activities, which includes hearing, eating, walking or moving, sleeping, speaking, breathing, learning, remembering, concentrating, and so on and so forth, right? These are all things we need on a daily basis to survive, to live. So these are what are known as major life activities. So if you have a mental or physical condition that substantially limits any of these, you could be considered a person with a disability under federal law. Under California law, it just needs to just limit any of these major life activities. Okay, so if we can go to the next slide, we have another question. And this is gonna test your knowledge or see if you can determine if a person is a person with a disability or not. So the question is, or the scenario and the question. So Alex is a person that was successfully treated for cancer about 2 years ago and is now in remission. Can Alex be protected under federal disability laws? So the first answer choice is no. Alex was successfully treated for cancer already and does not currently have a disability. Or B, yes, Alex has a history of a disability, so Alex can still be protected by federal disability laws. Okay, and then I'm just gonna briefly remind everybody. So remember, a person with a disability can be a person with a mental or physical impairment that under federal law that substantially limits a major life activity, or a person with a history or record of such an impairment, or a person that is regarded as having such an impairment. So those are the three categories. So here, is Alex a person with a physical or mental impairment that substantially limits a major life activity? Do they have a history of a physical or mental impairment that substantially limited a major life activity? Or is Alex regarded as a person with a mental or physical impairment that substantially limits a major life activity? Okay, so a few people answered. If we go to the next slide, we will reveal the answer. The correct answer is B, yes. So thank you for the person that maybe asked, is A the correct answer? So here the correct answer is B. And that's because under federal disability laws, to be protected, right, you need to be a person that has a physical or mental impairment that substantially limits a major life activity. So Alex here would not fall under that category because Alex no longer has cancer, right? However, if we go to the next category, a person with a disability can also be a person with a record or history of a physical or mental impairment that substantially limits a major life activity. Here, we know that Alex had cancer in the past, right, and is in remission, which means that the cancer can return at any moment. So under federal law, Alex can still be considered a person with a disability, even if Alex doesn't currently have cancer, active cancer. So the correct answer here is B. So good job, everybody. Thank you for participating. Okay, can go to the next slide. Okay, you see here a hand with a wad of cash here. So now we're gonna first provide an overview of Section 504, and then afterward we'll provide an overview of the ADA. So, and that'll explain the difference between the two laws, right, and how they work and what they can apply to. So Section 504 applies to groups or entities that receive any financial help or funding from the federal government. I know that there was a scare earlier this year because there was an executive order pausing federal financial assistance, but I just want to remind people that that order was rescinded or stopped for the time being. And many people, of course, challenged that order in court and will continue to do so if it becomes a problem again in the future. But that's all to say that this is still the case, right? Section 504 still applies to any group or entity that receives financial help from the federal government. And the truth is that several programs and agencies across the country do receive money from the federal government. So that means that they have to comply with this law, Section 504. So what are some examples of these groups or entities that can receive financial assistance, federal financial assistance? It can include public schools, colleges, universities. It can include government agencies, federal employers. It can include hospitals, clinics, nursing homes. It can include public transportation. And lastly, it can also include social services programs like welfare programs, housing assistance, vocational rehabilitation. So these are examples of entities that generally receive federal financial assistance, which means that they have to follow or abide or comply with Section 504. Okay, we can go to the next slide. So here you see a list of some ways that Section 504 can be violated or things that are against the federal law, Section 504. So one example is denying a reasonable accommodation request, which we will explain in the next slide. Also being prohibited from participating in programs or services simply because you're a person with a disability. Not making spaces or services physically accessible to people with disabilities. And also, an important one that's often forgotten is if you are retaliated against for exercising your legal rights under this law or Section 504. Okay, can go to the next slide. So reasonable accommodation. Some of you may be familiar with reasonable accommodations. Some of you may not, but we're just going to provide a brief explanation of what a reasonable accommodation is. So a reasonable accommodation is a change that can be made to policies, practices, or in environments of programs or settings that are made to help a person with a disability access a service, a program, or an activity. And these changes are made to ensure that people with disabilities can participate equally in various aspects of life in the same way that people without disabilities participate in various aspects of life. And this is determined in a case-by-case basis. And then again, we'll cover this a little bit later, but a reasonable accommodation cannot be an undue burden, right? You can always request that a change be made to a policy or a rule, but it cannot be an undue burden. In other words, the accommodation can't be too difficult to do or too expensive that it can't be afforded. So we'll provide an example of this. So let's say that there's a community center that receives federal financial assistance or federal funding. That community center, let's say, has a small and old swimming pool. If a person with a disability asks for a reasonable accommodation, right, they want to change. And what they want is they want a pool lift to be installed in the community pool so that it provides them equal access to the pool. This can be seen as an undue burden, especially if it would require expensive construction to the area, or if the community center just cannot afford it, too expensive. So this can be seen as an undue burden. And that community center will not be required to make that change, to make that reasonable accommodation. Of course, again, everything's looked at in a case-by-case basis. But as a general rule, if a reasonable accommodation request can be deemed an undue burden, an entity that receives federal financial assistance may not have to provide the reasonable accommodation. Okay, so we can go to the next slide. And we're going to give you examples of what a reasonable accommodation can look like, right? We know that it can be a change in a rule or policy or a setting, right? Or program setting. So examples include asking a community health center or a clinic that receives some federal funding to provide sign language interpreters or someone who for someone who is deaf or hard of hearing. Another reasonable accommodation could be asking a government employer that receives federal funding to provide flexible work schedules to accommodate important and necessary medical appointments that are related to a person's disability. Another example could be asking a public library that receives federal funding to provide screen readers for people who cannot see, which are software, right, that reads text aloud. Also asking a federal courthouse to allow a service animal to be present in areas where animals are usually not allowed. And then we'll talk a little bit more about service animals in a later slide. Something that I want to add is that when a person requests a reasonable accommodation, the agency, the program, the employer, they have a duty to engage in conversation with the person that's making the request. And this is what's called the interactive process. So they cannot just flat out deny a request without discussing it first. So for example, let's say I am a person who is deaf and I ask the clinic, the health clinic that receives federal funding to provide sign language interpreters. And they simply respond by saying no. With no discussion, they just say, no, we're not going to do that. That can definitely be considered against the law, or it can be considered disability discrimination. And this is against Section 504 and rights, laws that protect the rights of people with disabilities. So again, if you make a request for a reasonable accommodation, there has to be a discussion with whomever you ask that, make that request to. Great. And go to the next slide. Another question. This one's a little bit of a tricky one. So feel free to take some time. But here, the question is, out of these options, which one may be subject to or must comply with Section 504 of the Rehabilitation Act? And remember, Section 504 applies to entities that receive federal financial assistance. So we have four options. A public library that is only funded by the city of Los Angeles. B, a privately owned hotel located in Washington, D.C. C, a church that receives personal donations from a federal judge. Or D, Fresno High School, a California public school. So I'll allow people a few moments, right? And then we'll go over the correct answer. I know it requires a little bit of critical thinking. Great. Great. We'll give it another second or so and then okay. Great. Perfect. Thank you, everybody, for participating. We can go to the next slide to reveal the answer. And the correct answer is D. And then we'll explain why, right? I appreciate those that chose two answers because you're right. So, I mean, some situations you never know, but we'll explain why D is the only correct answer here. So remember, Section 504 applies to entities that receive federal funding. Here, the library is funded only by the city of LA, not the federal government. And the city of LA is a local government entity, right? It's not a federal government entity. So that would not apply here. The hotel is a private business, and private businesses don't generally receive federal funding. And even though the church technically receives money from a federal employee, right, a judge, the judge is actually donating in his individual capacity, not as a representative of the government. So that wouldn't apply. So here the correct answer is Fresno High School. And this was a tricky one because it doesn't say, right, specifically that it receives federal funding. But the truth is that most, if not all, California public schools, especially K through 12 schools, will receive money or funds from both the state of California and the federal government. So because of this, the schools have to follow the regulations or rules of Section 504 because they receive even some federal financial assistance. And one thing I will say before we go to the next slide is, although we're not covering special education issues here, some of you may know about 504 plans, right, in school, which are different from IEPs or individualized education programs. The reason they're called 504 plans is because the law that applies is Section 504 of the Rehabilitation Act of 1973. And that's because the schools receive federal funding, so they must comply with that federal law. And that's where Section 504 plans originate from. So just a little bit of a tidbit there. Okay, we can go to the next slide. Okay, so that was Section 504, right? And the takeaway, right, is, you know, entities that receive federal financial assistance or federal funding must make sure that they don't discriminate against people with disabilities, and that they must provide rights that are due to people with disabilities, including reasonable accommodations. Okay. So now let's switch gears to the Americans with Disabilities Act, or the ADA. So the ADA actually expands on Section 504 and provides protections in the following areas. It provides protections in the area of employment, which is known as Title I of the ADA. We won't cover this title in this presentation, but I will say that this applies to generally to employers with 15 or more employees under federal law. And I will say California law has more protections, right? Because it can. And California has its own law called the California Fair Employment and Housing Act, or FEHA, we call it FECA, that only requires 5 or more employees to be covered under that law. So next, we also have Title II of the ADA, which we will talk about, and that applies to state and local governments. For example, the city of Los Angeles. Next, we have Title III of the ADA, which is public accommodations. And that's the term they use, but all that really is just private businesses that are open to the public. And lastly, we have Title IV of the ADA, which covers telecommunications. We're not going to discuss that title today, but it essentially covers telephone and television access for people with hearing and speech disabilities. So today we will only be discussing Title II and Title III of the ADA, which, of course, every title is important. But to give you just an introduction, we thought we would first cover Title II and Title III during this presentation. Okay, and go to the next slide. So here we have some key concepts of the ADA. And of course, for some of you who registered for this presentation, you will receive a copy of this slide. So if you want to review it later, you certainly will be able to do that. So key concepts of the Americans with Disabilities Act. So one is equal access, and that means that people have the right to participate in the same benefits, same programs, and same services in the same way as those without disability. Integration. This means that the government has to provide services where people with disabilities can be included with others as much as possible. Removal of barriers. That means that the government and private businesses that are open to the public must make sure that there are no physical barriers, because people with disabilities need to have access to these spaces. Reasonable accommodations, which we've already discussed. And lastly, effective communication, which essentially means that governments and private businesses open to the public have to provide auxiliary aids and services. And that's the term that is used, and we'll explain this in a later slide. But these are tools and instruments and services that make sure that people can communicate effectively with others. Okay, and go to the next slide. So Title II, we'll start with Title II of the ADA, which applies to state and local governments. So state and local governments can't discriminate against people with disabilities. And this applies to almost everything that the state and local government does, including, again, public education, which includes K through 12 schools, community colleges, California state universities and universities of California, also public transportation, healthcare, court systems, voting systems, recreational programs, social services, and even jails or prisons. And go to the next slide. Okay. So under Title II of the ADA, state and local government has to do certain things. And they also are prohibited from doing other things. So let's talk about what state and local governments have to do. So they have to make reasonable accommodations whenever it's necessary. They, again, we'll discuss this in a later slide, but they have to provide auxiliary aids and services to make sure that people can communicate effectively. They have to remove barriers, physical barriers, right, that provide access in order to provide access for people with disabilities. Now, what can't state and local governments do? So they can't refuse to provide services to qualified people with disabilities. They can't provide segregated services to people with disabilities. And that's all about inclusion, right? We want to include people with disabilities in the same spaces, same programs, same services as people without disabilities. Another important one is that state and local governments can never charge a fee for providing a reasonable accommodation. And that's for reasonable accommodations generally. A fee should never be charged if you make a request for a reasonable accommodation. Okay, can go to the next slide, which is another question. A little hypothetical in the question. So if a person who is deaf or hard of hearing requests an ASL interpreter at a local courthouse as a reasonable accommodation, can the courthouse charge a fee? You have three answer choices: A, yes; B, no; or C, maybe. Hopefully this one's an easy one. Okay, we'll give it a few moments. Thank you, and I appreciate all of you participating. Okay, great. Thank you. I think we can go to the next slide and reveal the answer. Perfect. Thank you, everyone. So the correct answer is B, no. So a local courthouse can be considered a state or local government entity or a public entity. So under Title II of the ADA, it cannot charge a fee for providing a reasonable accommodation. Here, an ASL interpreter is being requested as a reasonable accommodation. Again, though, the truth is that under any circumstances, there should never be a cost to provide a reasonable accommodation. Whether it's a state or local government, whether it's if it's an entity that receives financial federal assistance, there should never be a fee. Okay, we can go to the next slide. Okay, this one's a more interesting one, right? Because I think this is something that we encounter every single day of our lives. So Title III of the ADA, or public accommodations. So what is a public accommodation? I did mention it earlier, but it's a private business that is open to the general public. And we have a list here of what kind of entities or private businesses they can be, right? They can be restaurants, hotels, theaters, stadiums, department stores, shopping centers, grocery stores. Basically, it goes on and on, right? The list. There are a few private businesses that wouldn't be covered. And I'll give you an example of one of the major ones are religious institutions, right? Although people have their thoughts, right, whether they're businesses or not, but either way, right, they're private entities. And although they can be open to the general public, they're generally not applicable here. They're not considered public accommodations under Title III of the ADA. Okay, we can go to the next slide. So we'll go over some of the major rules, right, for Title III of the ADA which applies to private businesses that are open to the general public. So again, private businesses can't exclude people with disabilities from their services. They have to make reasonable accommodations unless it's an undue burden, which we already discussed, or a fundamental alteration, or it creates a direct threat. And I'm going to explain, I'll give you an example of what a fundamental alteration is and what a direct threat is. So a fundamental alteration is something that would completely change the nature of a business's operations or their services. And an example that I like to use that is kind of funny, interesting, not funny. I shouldn't say funny, but an example is let's say we have a person with a disability, and part of their disability is that they have a lot of allergies. So that person with allergies asks a restaurant as a reasonable accommodation to offer a completely new food menu, right? And to change its cooking style, to change its kitchen equipment, to train their staff, to change their marketing, because the specific allergen or things that they're allergic to, they're present in this restaurant for whatever reason, right? Basically changing the entire dining experience of that restaurant. So that can be seen as a fundamental alteration. It's an extreme example, but yes, that's an example of what a fundamental alteration can be considered. All right, it wouldn't be reasonable to expect a restaurant to change its dining experience because a person requests a reasonable accommodation due to their allergy, right? So that's fundamental alteration. Now, direct threat. A direct threat is when the risk of harm or danger would make it very difficult to provide the accommodation. An example of this, a very interesting example I'll use here. So let's say we have somebody with a severe seizure condition or disorder who wants to participate in intense cardio classes at the gym, right? The gym is a private business open to the public. So this can be dangerous to the person with the disability and to others around that person. If they, for example, can suddenly lose consciousness, that can result in serious injury or harm. So this can be considered a direct threat, right? Which means that in that case, the business, if, for the safety of the person with the disability and for others around them, right, they may not necessarily be required to accommodate that person. Again, that's another extreme example, and which again, these are all fictional. So, but I think they help illustrate the ideas of direct threat and fundamental alteration. Now let's talk about service animals. We do presentations that cover a lot more about service animals and emotional support animals, but here we'll just provide you very basic information about service animals and emotional support animals. So private businesses that are open to the public have to allow service animals, but they don't have to allow emotional support animals because they're different. So service animals are dogs, or they can also be miniature horses, right? That can be trained to perform a specific task. Some examples of that, right? You can have guide dogs, right? Who help people who are blind. You can have dogs that can detect elevated levels of sugar levels, right? For a person who's diabetic. You can have a psychiatric service dog, right? That helps, for example, a person with autism or PTSD to calm them, right? With deep pressure therapy, for example. So there's different types of service animals. But that's different from an emotional support animal. An emotional support animal can be any domesticated animal. For example, a cat, dog, a bird, even a snake, right? in some situations, depends on the type of snake, that provides emotional comfort due to a mental health disability or impairment. And though private businesses that are open to the public are not required to allow emotional support animals in their establishments, housing providers like apartment buildings or mainly the most common example are apartment buildings or condos, right? Or any community living situation, they may be required to allow emotional support animals as a reasonable accommodation, which means that they cannot charge you a fee to have that emotional support animal in your home or apartment. So for service animals, if you're in a business open to the public, you don't need to show you don't need to show proof, right, that you're a person with um, a disability that requires a service animal. These businesses can only ask you two questions, and you've probably seen it on social media, right? Those two questions are, is that a service animal? And what task or tasks is it trained to perform for you? And you don't have to disclose the nature of your disability, right? And that's important. And there's a lot of businesses out there that are probably not well informed about people with disabilities' rights to service animals. So they'll have this misconception that you need to have a vest or something denoting or signaling that you have a service animal. It's helpful, but it's not required. Okay. And of course, the other thing that we have here on the list is auxiliary aids and services for effective communication. So if we go to the next slide, we're finally gonna explain a little bit more about what auxiliary aids and services are. So auxiliary aids and services are tools or support that help people with disabilities communicate effectively and to access information. So the ADA requires entities to provide these aids and services to make sure that people with disabilities can participate equally and communicate effectively with people with other people with disabilities or people without disabilities. If we go to the next slide, we have some examples of what these tools and supports can be. One is sign language interpretation, which can include video remote interpreting. So for people who are deaf or hard of hearing, right, video remote interpreting is where you have two individuals, right, who are signing via a video screen. You usually need internet connection, and they can communicate remotely with one another. And it'll be a person who speaks sign language interpreting for the person that doesn't speak sign language. In this case, for a person who may be deaf or hard of hearing. We also have assistive listening tech devices. And those are devices that make sounds louder for people who are hard of hearing. We also have captioning. And you often see these on videos, of course, which is just display of written text of spoken words on a screen. Braille materials. We also have easy to read materials, including providing documents in large print size or providing materials in plain language. Plain language is using words that are easy to understand. And yes, I mean, sometimes when you have to communicate with lawyers, right, in writing as well, they use a lot of legal terminology, but you know, as an organization, we do our very best to make everything as plain language as we can. Sometimes it's difficult, but you know, we do our very best. Another one is accessible electronic information, which can include, for example, screen readers, which again are computer applications or software that read text out loud for people who are blind. or who have a visual impairment. Okay, so we can go to the next slide. Next, we have, we're not going to go delve into this too deeply, but you can refer to this when you get a copy of the presentation. But I do want to just generally state that the ADA has something called the ADA Standards for Accessible Design. And this is a guide for several entities, businesses that are open to the public, or local government entities that requires their buildings or facilities to be physically accessible to people with disabilities. So it's a list of rules and things that have to be followed. So you can take a look at this. It's a pretty large document, but it's helpful, right? Because it goes into every detail, every specific requirement that a building must have or must abide by or comply with in order to make their buildings and physical spaces accessible to people with disabilities. And in fact, I mean, for some of you that may be curious, I'm just going to put the website, the web page on the chat. Okay, we can go to the next slide, which is another question. And this is going to be kind of a test of whether you can distinguish between the laws that we just covered, the federal laws. So the different titles of the ADA and Section 504. So the question, the scenario and the question is, a student with a disability at a California public school that receives federal funding was denied a reasonable accommodation request. So what federal law or what federal laws could apply here? We have A, Title II of the ADA, B, Title I and Title III of the ADA, and I will go over them briefly again for you. Option C, Section 504, or D, Section 504 and Title II of the ADA. Okay, so I'm going to go over them. So let's start with the ADA, the different titles of the ADA. Title I of the ADA pertains to employment. Title II of the ADA pertains to local government entities, right? State and local government entities. Title III, yeah, I can go through all the titles. Title III of the ADA, again, process of elimination, right? That applies to private businesses that are open to the public. And although Title IV is not here, Title IV applies to telecommunication. And then lastly, Section 504 applies to any entity that receives federal financial assistance. So here we have a California public school that receives federal funding. So what would apply here? We'll give it a few moments. This is probably the most difficult question out of all the ones that we've had. But I see that a lot of you are getting the correct answer. So let's go to the next slide and reveal the correct answer. Yes, a lot of you got it correct. Option D is a correct answer here, Section 504 and Title II of the ADA. But we know Section 504 applies to entities that receive federal financial assistance. Here, we're told that this California public school receives federal funding. So that would apply. Title II applies to local and state government entities, right? That can include public schools, right? Local public schools. Here we know this is a California public school, so we know that they likely receive state, or they're considered a state government entity or receive funding from a state government entity. So Title II would apply. So here, D is a correct answer. Title III doesn't apply here, right? Because the California public school is not a private business open to the general public. So, but good job, everybody. Good job. We can go to the next slide. Here we have just a pretty decent recap of Section 504 in the ADA. Again, I want to remind everyone that these are two important federal laws protecting people with disabilities, but they are not the only laws. There are other federal laws and California laws that also protect people with disabilities. So to provide a brief recap of how Section 504 and the ADA function, right here in the middle, you see a blue circle, which has things that Section 504 and the ADA have in common. First, both of these laws were created to protect people with disabilities against discrimination. Second, these laws protect people with physical or mental impairments that substantially limit one or more major life activities, or people with a history of such an impairment. To the left and to the right, you see two green squares, and these both show the major differences between Section 504 and the ADA. Again, Section 504 applies to agencies, programs, or organizations that receive some or complete financial federal assistance. And the ADA, on the other hand, applies in the areas of employment, to state and local government services, to private businesses open to the public, and telecommunications. Sometimes both laws will apply, right? Like in the example we had with the California public school, sometimes both laws will apply. Okay, so now we can go to the next slide. Now let's talk about self-advocacy, right? So now we learned a little bit about, we were introduced to Section 504 in the ADA. So with that information, what do we need to know in order to advocate for ourselves? So let's talk about reasonable accommodations. So we now know what a reasonable accommodation is. So how do we put that into action, right? So if you need an accommodation or an auxiliary aid, you can ask for one as soon as possible, whatever entity it is. It could be a school, right? It can be a medical clinic. It can be a public library. It can be a grocery store. You don't have to make these requests in writing, but you should. You should always it's always advisable to make the request in writing so that you can have proof that you made the request. And most entities will have a person that is in charge, right, of overseeing accommodations, of overseeing or making sure that the entity is complying with the law, civil rights laws. These people are sometimes called ADA coordinators or civil rights coordinators. And this person ensures that the agency, organization, or business is following the rules or following the federal laws. So that person can help you resolve issues without you having to take more legal action. So, you can ask around, try to figure out if this person exists within that entity. And when you make these reasonable accommodation requests, you do need to explain why your request is necessary because of your disability. Again, you don't have to share all of your private medical information. You just have to explain enough to make your needs clear. Say, for example, we'll revert back to that example of the person who is deaf, right? And they require ASL interpretation. If I go to a public library, right, and I need help from a clerk or something, I can ask to be provided ASL interpretation. And I just need to demonstrate that I'm a person with a disability. I have a disability-related need for ASL interpretation. And that's all that's required, right? And of course, things can be a little bit more complex depending on the type of disability and the type of entity. But as a general rule, if you're a person with a disability and you need a change in a rule or a policy, or you need something changed in order for you to access a program or service, you're entitled to that. Okay, we can go to the next slide. So we've already explained what discrimination is, right? It refers to treating someone unfairly or differently because of certain characteristics, including disabilities. So a lot of agencies or programs have a complaint process or a grievance process. And for example, if you feel like you've been discriminated against, you feel like you've been treated unfairly because you're a person with a disability, let's say within your health plan, right, through Medi-Cal. You can submit a complaint directly to Medi-Cal, a grievance, letting them know I'm a person with a disability. I was treated unfairly. I had a disability-related need and it wasn't met. That could be seen as discrimination. You can file a grievance or complaint. But sometimes, right, people will do that, but the issue is not resolved. So what do you do after that? If that doesn't work, you always have the option of submitting what's called an administrative complaint. Let's say, for example, that you ask for a reasonable accommodation at a health clinic and it was improperly denied, or you feel that the health clinic took action against you because of your disability. And you try to make a complaint directly with, let's say, the manager of the health clinic. And the issue wasn't resolved, right? You were ignored. At that point, you can take it further. You can file an administrative complaint. In this case, it could be with the Department of Healthcare, right? So these are formal complaints made with a government agency that handles claims related to discrimination. In this, right, help or guidance from a legal professional is helpful, right? Like organizations like ours can definitely help with those types of situations, but it's not required to file these complaints. You know, sometimes let's say you want to sue like a business, right? Oftentimes you need a lawyer to do that, right? To go to court, to file a complaint for you. But for these administrative complaints, you don't need a lawyer. It's helpful to have somebody that is knowledgeable about the law, but it's not required. So here we have a list of the various ways you can file an administrative complaint with the federal or state office. So for employment, right, we have two, the U.S. Equal Employment Opportunity Commission. For California, that's the California Civil Rights Department. We have some links to housing administrative complaints. We also have some to education administrative complaints. And we don't have the California ones because that's going to depend what county you're in. We have one for healthcare, one for public transit and air travel when you're traveling by plane. You know, there's a lot of people, for example, with service animals who are discriminated against when on planes, right, when traveling by plane. So we have some links if you want to file an administrative complaint. And then at the end, right, if none of these areas apply, you can always go to the U.S. Department of Justice, the Civil Rights Division. You can file a complaint that way as well. Another thing I have to add, right, is that a person, you know, they can file these administrative complaints, but they can also sue in court if they have been discriminated against, though that does generally need to have an attorney involved. But that option is always available. But administrative complaints, you don't need an attorney. It's helpful to have somebody with knowledge, but it's not required to file them. Okay, we can go to the next slide. Here we have a few resources for you, right? Our DRC or Disability Rights California has a bunch of publications. that can help you with all sorts of issues, including disability-related discrimination. We have 2 links for that here. We also have a link to the US Department of Justice that has a website dedicated to the ADA. They have a lot of resources and publications that you can look at. We also have a link to the National Council on Disability, which does a lot of things, but it does provide public education on various issues faced by people with disabilities. And then we also have a link to the ADA network, which is another resource that provides information regarding the ADA. Can go to the next slide. And lastly, I just want to share our intake phone line information. So, we are a nonprofit agency that provides free legal services to people with disabilities. We have an intake line where you can call to get some short-term legal assistance. It's available Monday, Tuesday, Thursday, and Friday from 9 a.m. to 3 p.m. Our intake line is closed on Wednesdays. Also, if you cannot call during that time, we also have an online intake form that you can fill out, and one of our legal advocates will reach out to you right at a time that is great, good for you, or when you're available. So just know that there's that option. And I think saying that, I think maybe we can stop the recording so people have specific questions, we can answer them.
Thank you, Dan.